Hello friends, welcome to my channel. Today I am going to discuss about this question number 7 of industrial labor and industrial law 2015 question paper. The question is, explain different kinds of disabilities under the Workmen's Compensation Act. What are the defenses of the employer against a claim of compensation under the Act 1923, of course. So for this purpose, first of all, we'll discuss about the classification of disabilities under the said act and along with some important case laws. So let's begin. Then comes meaning of disablement. Disablement, it is the expression disablement means loss of capacity to work, or in other words we can say loss of earning capacity or reduction of earning capacity, or the thing which incapacitates a person to work. Disablement is reduces the earning capacity of an employee. Injury caused to an employee by an accident resulting in the loss of earning capacity is technically called disablement. So this is the real meaning of the word disablement. Injury caused to an employee, there must be some kind of injury. The injury must be caused to an employee by an accident. The injury may be result of an accident. The accident must occur in the workplace, or they must arise during out of the course of the business, out of the course of the employment. Then comes this must result in loss in earning capacity. Injury may result in death or disablement. In case of disablement, it is defined as loss to reduction of earning capacity, which is technically called disablement. In other words, a person is incapacitated to work or to move as a consequence of an accident. Now there must be injury. Injury must arise out of accident. The accident must occur in the workplace, and then all these things must result in either death or disablement. In case if it is the disablement, it may be of various kinds like permanent disablement, temporary disablement, partial disablement, or total disablement. That's a disablement, loss or reduction of earning capacity. It may be total and partial. It may be permanent and temporary. Now, total and partial, this is the extent of the disablement. And permanent and temporary, this is the nature of the disablement. And here we find a classification of disablement. Disablement classified into total, partial. It can be further classified as temporary, permanent. Disablement, whether permanent or temporary, is said to be total when it incapacitates an employee for all the work he was capable of doing at the time of the accident, resulting in just disablement. Then comes relevant provisions for this purpose. We have to read section 2(1)(g), which deals with mainly partial disablement, the definition of partial disablement, and section 2(1)(l), which deals with the definition of total disablement. Relevant provision under Employees Compensation Act 1923. Then these are the provisions of the Act. Section 2(1)(g) provides the definition of partial disablement. Partial disablement means where the disablement is of a temporary nature. The partial disablement may be of temporary nature as well. Such disablement as reduces the earning capacity of a workman in any employment in which he was engaged at the time of accident, resulting in the disablement. So it is partial, first of all, not total, and again it is just temporary for a limited period of time, not permanent. And where the disablement is of permanent nature, so there may be permanent partial disablement as well. So if it is of permanent nature, means it permanently incapacitates a person. Such disablement as reduces the earning capacity in every employment which he was capable of undertaking at that time. Provided that, provision to section 2(1)(g) provides that, provided that every injury is specified in part 2 of schedule 1. So schedule 1, here it is part 2, shall be deemed to result in permanent partial disablement. Every injury is specified, the kinds of injuries are specified in part 2 of schedule 1. Those injuries which are specified in part 2 of schedule 1 shall be deemed to result in permanent partial disablement. Of course, disablement, as we know, it means reduction of earning capacity or loss of earning capacity. Partial means it is not total disablement. He is not totally disabled to work, but he is just partially disabled or incapacitated to work. Then comes permanent, but the nature of the disablement or injury is permanent, not temporary. Then comes section 2(1)(l). total disablement, which defines the definition of total disablement. Total disablement means such disablement, whether of temporary or permanent nature. Total disablement may be of two kinds, permanent and temporary and permanent. Whatever nature it may be, which incapacitate, it must be of such a nature that it incapacitates an employee for all work which he was capable of. All word is very important. All work which he was capable of performing at the time of the accident, resulting in such disablement. Because it is total disablement, it totally disables the person and not partially disables him. It may be temporary or permanent as well. So provided that permanent total disablement shall be deemed to result from every injury, provided that permanent total disablement shall be deemed to result from every injury specified in part 1 of schedule 1, where we find that part 2 schedule 1 mainly deals with permanent partial disablement. So part 1 schedule 1 deals with permanent total disablement. Here it is partial, here it is total. Shall be deemed to result from every injury specified in part 1 schedule 1 or from any combination of injuries specified in part 2 thereof. Where aggregate percentage of loss of earning capacity as specified in the said part 2 against whose injury amounts to 100% or more. Then comes temporary, then comes classification. Then comes temporary disablement. Temporary disablement means disablement in doing normal work lasts continuous for a temporary period, only temporary period. Temporary disablement is subdivided into following two heads: temporary total disablement, temporary partial disablement. Temporary total disablement. Temporary total disablement incapacitates a workman to do every work which he could do. It lasts for temporary period, of course temporary, not permanent, but it incapacitates a workman to do every work. Then comes temporary partial disablement. It means temporary partial disablement reduces the earning capacity of the workman in doing every work which he could do well before the accident. It lasts for a temporary period only, partially disables him only. Then comes permanent disablement. Permanent disablement means disablement arising out of accident, arising out of the accident. It lasts forever. For example, forever, that's why it is permanent. For example, permanent in nature. It's subdivided under the following two heads: permanent total disablement and permanent partial disablement. Permanent total disablement means if an employee as a result of an accident suffers from injury specified in part 1 of schedule 1, the Workmen's Compensation Act 1923, or we can say that Employees Compensation Act 1923, or suffers from such a combination of injuries specified in part 2 of schedule 1 as well, not only part 1 schedule 1, but he may suffer from such combination of injuries as specified in part 2 schedule 1, as will bring the loss of earning capacity when totaled to 100% or more. Such an injury is said to be permanent total disablement. It may be 100% or more. To determine whether the injury is permanent or temporary, the total effect of injury to the employment opportunities of the employee. The keyword here is employment opportunities to the employee, which we are going to discuss for various case law in this video as well. So whether the injury is permanent or temporary, the total effect of injury on the employment opportunities is an important word, of the employee concerned is the deciding criteria. And for this we are going to read some case laws in this lesson to clarify our points. In simple words, the accident incapacity loss of 100% earning capacity forever. The accident loss of 100% earning capacity forever, for example, permanent in nature. It is total as well as permanent. So the most dangerous kind of disablement. Injuries are listed in part 2 of the schedule. Injuries are listed in part 2 of the schedule 1. Reduces 100% earning capacity forever. For example, loss of both the hands, 100%, loss of one hand and one foot, disfigurement, absolute deafness, etc. Disfigurement, absolute deafness, etc. So these are some of the examples. Then comes permanent partial disablement. Permanent partial disablement reduces earning capacity in every work. Permanent, although it is permanent, but it is partial. Every work which he could do well. It is permanent in nature. Every injury specified in part 2 schedule 1 is deemed to be permanent partial disablement. Part 1 schedule 1 contains 14 injuries. For example, loss of thumb 30%, loss of 4 fingers of one hand 50%, etc. So we have to see the schedule in order to understand it properly. So this is the list which provides schedule 1. Schedule 1 provides part 1 and part 2. Part 1 deals with permanent total disablement. Part 2 deals with permanent partial disablement and the percentage in all the cases. So this is the schedule which you can read. Middle finger hold 12. For example, you can see loss of 4 fingers of one hand 50% only, and it is under the permanent partial disablement. So now we're going to discuss about certain relevant case laws. The first case number 1 is Upper Doba Sugar Mills Ltd versus Daulat Ram. So we have to remember the title. Upper, UPPR, Upper Doba, DOABA, Doba. Upper Doba Sugar Mills Ltd. This is the sugar. Okay, sugar. Upper Doba Sugar Mills Ltd versus Daulat Ram. Daulat Ram. Daulat Ram. This is the title of the case. Upper Doba Sugar Mills Ltd versus Daulat Ram. What was held in this case? A blacksmith had lost the index and middle finger. So there was a blacksmith who had lost the index and also the middle finger, and the rest of the hand, merely the thumb and other 2 fingers, could be utilized in the work. So he had lost 2 fingers, but the rest of the 3 fingers can be utilized in work. The test laid down in this case to determine the nature of the disablement. So what was the issue in this case? To determine the nature of the disablement, whether it was permanent, temporary, partial, or total. So it is not enough. What was held in this case? These lines are under the quotation. It is not enough if it is found that the employee is disabled from performing his duties of a blacksmith fitter. The court should consider whether he has been incapacitated from undertaking any employment, not only disabled him from performing his duties of a blacksmith fitter, but court should also consider whether he has been incapacitated from undertaking any employment, and whether in that other employment the rest of the hand could be utilized. Whether in the other employment, not as a blacksmith, the rest of the hand, which does 3 fingers, can be utilized or not. So this was the nature of disablement. Then comes another case, General Manager GRP Railway Bombay versus Shankar. So General Manager, okay, he was the General Manager of GRP Railway Bombay versus Shankar, 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 a railway servant working on A1 post. Okay, he was a railway servant who was working on A1 post, lost 1 eye and 2 teeth as a result of collision between 2 engines. He lost 1 eye. He lost 1 eye and 2 teeth as a result of collision between 2 engines. And he was a railway servant working on A1 post. He was declared by the medical officer as unfit for A1 and B jobs, but fit for C2 job because of his defective vision. So, as declared by medical officer, he was unfit for A1 and B jobs, but was fit for C2 job because of his defective vision. Class C2 job was offered to him by the railway administration. As a result, C2 job was offered to him by the railway administration. He refused the offer and claimed compensation on the basis of total disablement. So what he claimed, he refused the offer of C2 job and claimed compensation on what grounds or basis? On the basis of total disablement. So it was held that the employee was entitled to compensation not on the basis of total but partial disablement. So it was only partial disablement. Obviously, in this case, there appears only reduction in earning capacity as an alternative employment. What was the rationale behind this partial judgment? Obviously, in this case, there appears only reduction in earning capacity as an alternative employment was offered to the employee by the employer himself. That's why, because the alternative employment was offered to the employer, and in only appears only reduction in earning capacity in certain kind of jobs only. So it was a partial disablement, though he was entitled to compensation, but not the total disablement as he contended or claimed. In this case, where an employee suffered an injury by accident which did not in fact reduce his capacity to work but stamped him with a visible mark of physical deficiency or deformity as dissuaded the likely employers from employing him, he will be deemed incapacitated for work in the sense that his earning capacity will clearly be altogether destroyed. Although his disablement was of partial nature, but because he has lost one eye and two teeth, so but the accident which did in fact reduce his earning capacity. In what sense? To work, but stamped him with a visible mark of physical deficiency. He had the visible mark of physical deficiency as dissuade the likely employers from employing him. He will be deemed incapacitated for work because future employer may not employ him due to his physical deficiency or deformity, although he may be able to work. That's why he will be deemed incapacitated for work in the sense that his earning capacity will clearly be altogether destroyed. This case is important, and facts of the case is also interesting. So the title is General Manager GRP, General Manager GRP, RP. Then comes Railway Bombay versus Sankar. Very important. Then comes another case. What was held in this case? Sukhai versus Hukum Chand Jute Mills Ltd. Sukhai, Sukhai, Su and Khai, Sukhai versus Hukum, Hukum, Hukum Chand Jute Mills Ltd. Sukhai versus Hukum Chand Jute Mills Ltd. So this is the title of the case. Sukhai was employed as a copwinder in the jute mill of the respondent. Employed as a what? Copwinder in the jute mill of the respondent on 16/12/1951. On 16/12/1951, while he was at work, his left eye was injured. Left eye was injured by some flying Chinese clay balls. Flying Chinese clay balls. Injured. He was given first aid by the chief medical officer and then sent to the Chinsura hospital where his eyeball was removed. His eyeball was removed in that hospital. Okay. He assumed his duty on 5/9/1952. Resumed his duty on 5/2/1952. He had been in the employment of the respondent company and was earning his usual wages and could do his usual work. On 4/6/1952, he made an application for compensation for injury to the eyes. He described the injury as loss of vision of the left eye because the eyeball was removed. The injury was what kind of? He lost the vision of the left eye according to him because eyeball was removed. It was held that the court could make a suspensory award. What kind of award is this? Award is under the quotation. Suspensory award. A suspensory award could be made when present earning capacity of employee was not affected. Although the present earning capacity of the employee was not affected but was likely to affect the capacity in future, as it is same we have seen in the previous case. In such a case, the court could make a declaration of the employer's liability when the evidence was fresh and then adjourn the matter, reserving to each of the parties liberty to make such application in future, as they might be advised. It was further observed that if an employee suffers as a result of an injury from physical defect, which does in fact reduce his capacity to work but at the same time makes his labor unsellable. The word labor unsellable is very important. In any market reasonably accessible to him, there will be either total incapacity for work when no work is available to him at all, or there will be partial incapacity when such defect makes his labor sellable for less than it will otherwise fetch, in less price, that means. So the capacity of an employee may remain quite unimpaired, but at the same time his eligibility as an employer, the question of eligibility comes here. Eligibility as an employee may be diminished or lost. So if such a result endured by the reason of the result of an accident where his labor may become unsellable or sellable for a less price or may make him ineligible for future employment, then if such a result endures by the reason of the result of an accident, if such a result has direct connection with injury or accident in the workplace, although the accident has not really reduced the capacity of the employee to work, although it has not really reduced, then he can establish a right of compensation, provided he proves by satisfactory evidence, provided that he must provide satisfactory evidence that he has applied to a reasonable number of likely employers for employment. What evidence is necessary for this purpose? Let's see here. Satisfactory evidence that he has applied to a reasonable number of likely employees, that the person has applied to a reasonable number of likely employees for work, of course, for employment, but had been turned away on account of the result of the accident visible on his person, as his eyes has been destroyed, the eyes has received injury, or some other kinds of physical deformity has resulted in unemployment. Means the employer are not willing to take him. Then it was also contended on behalf of the respondent and the appellant was already blind of his left eye at the time of accident, and that the schedule to the act was concerned only with the loss of a sound organ. So of course we have the schedule. In the reply to this, the court said that in that event the injury will be a non-scheduled injury. It will be a non-scheduled injury and compensation will then be payable under section 4(1) clause C Roman 2 of the Act if permanent partial disablement was otherwise proved. That problem was also clarified by the court. So let's read the title of the case again because it's really very important. Many points are there in this case. Sukhai versus Hukum Chand Jute Mills Ltd. We have to remember Sukhai versus Hukum Chand Jute Mills Ltd. Then comes another case, New India Assurance Company Ltd. versus Gautam Appa Rao and another. The disability certificate issued by the doctor estimated disability at 50% and noted partial permanent disability. Partial permanent disability. Of course, the disability is permanent, but it is partial. That's why it is only of 50% disability. He cannot drive the vehicle. It was a non-scheduled injury because it was not included in the schedule of this act, and the compensation commissioner held it as a case of total disablement and estimated injury to be 90%. It was the discretion of the compensation commissioner who held that it held it a case of total disablement and estimated injury to be 90%. In appeal, it was contended that the commissioner has no power to enhance the disability suo motu. He has enhanced the disability from 50% as estimated by doctor to 90%. What was held in this appeal? It was contended that the commissioner has no power to enhance the disability suo motu. It was held that from the note of the doctor, it is clear that the employee cannot work as driver of motor vehicle. The permanent partial disablement suffered by employee, permanent but partial disablement suffered by the employee is not by virtue of an injury specified in Part 2, Schedule 1 of the Act. In view of observation of the doctor, the commissioner was right in holding the disablement as total in view of the definition in clause L of Section 2(1), because it was a non-scheduled disablement or injury, not by virtue of injury specified in Part 1, Section 1, Schedule 1, Part 2, Schedule 1. So the commissioner was right. Now let's read the case again. New India Assurance Company Ltd. versus Gautam Appa Rao and another. So now name of the person is Gautam, K-O-T-A-M, Gautam Appa Rao and another. New India Assurance Company Ltd. versus Gautam Appa Rao and another. Then this is the last case. Mohan Soni versus Ram after Tomar and others. Mohan Soni versus Ram after Tomar and others. The appellant, a carpooler, was hit by a motor vehicle, as a result of which he suffered injury, and his left leg below the knee was amputated. The Motor Accident Claim Tribunal as well as the High Court did not grant him adequate compensation. Motor Accident Claim Tribunal (MACT) as well as HC High Court did not grant him adequate compensation. Hence, he preferred appeal to the Supreme Court. Allowing the appeal of the Supreme Court observed that for a carpooler like the appellant, loss of one leg will be the end of the road insofar as his earning capacity was concerned, unlike a person engaged, say, in some desk work in an office. The court below erred in paging down the disability of appellant to 50% with reference to Schedule 1 of the Workmen's Compensation Act 1923. Therefore, it was held that the loss of earning capacity might be as high as 100%, but in no case it will be less than 90%. Because it was, what was the reason behind this? The court observed that for a carpooler like the appellant, loss of one leg will be the end of the road because we will never be able to do so. Insofar as his earning capacity was concerned, unlike a person engaged, say, in some desk work in office, because it depends on the nature of the work as well. That's why the earning capacity might be as high as 100%, but in no case it will be less than 90%. So it may be 90% to 100% earning capacity, 100% loss of earning capacity, not 50%. Consequently, compensation of total sum of 4.01 lakh was awarded to appellant. Compensation of total sum of 4.01 lakhs was awarded to the appellant with interest at ₹9 per annum from date of filing of the claim petition. That's all.